Good evening, everyone. My name is Sanjeev Anand, and I am the Dean of the College of Law at the University of Saskatchewan. It is my distinct pleasure to welcome you to this year's Gertler Family Lectureship in Law. This lectureship is devoted to subjects related to law and ethics, and it is sponsored by Dr. Menard Gertler, a distinguished alumnus of our university and an internationally renowned cardiologist who established the lecture series to honor the Robert McKercher family. We are very pleased that members of the McKercher family are able to join us tonight. In particular, I would ask that Bob McKercher, QC, and Peggy McKercher, Chancellor Emeritus of the University of Saskatchewan, stand and be acknowledged. Both of these individuals are pillars of our community, and without their support and assistance, we would be unable to put on this wonderful lecture that you are about to be treated to tonight. A key reason that this year's lecture is so auspicious is because of the lecturer, and I will introduce Professor Laurel Terry in just a moment. But before I do, I would like to acknowledge a number of special guests in attendance tonight. We are pleased that the President of the University of Saskatchewan, Dr. Eileen Bush-Vishniak, is here tonight. And President Bush-Vishniak, if you could stand and be acknowledged as well. We are also very fortunate that former Law Society of Saskatchewan President Greg Whalen, QC, and the current Executive Director of the Law Society of Saskatchewan, Tom Schonhofer, QC, are here with us, as well as Associate Chief Judge Irwin of the Provincial Court of Saskatchewan. Gentlemen, if you would mind standing. On to our main event, Professor Laurel Terry. Professor Terry is the Harvey A. Feldman Distinguished Faculty Scholar and Professor of Law at Pennsylvania State University's Dickinson School of Law. Sorry, that was a bit of a mouthful. She writes and teaches in the area of legal ethics and the international and interjurisdictional regulation of the legal profession. A 3-time Fulbright grant recipient, her research interests include structural reforms pertaining to governance of the legal profession in the United Kingdom and Australia, legal outsourcing, the application of the World Trade Organization GATT agreement to legal services, lawyer confidentiality, and the Financial Action Task Force recommendations, the application of EU competition antitrust policy to legal services, and the effect of the Bologna process on legal education. Her most recent articles have been about global trends in lawyer regulation, the importance of regulatory objectives, and the need to create a global umbrella for lawyer regulators. An elected member of the American Law Institute, Professor Terry is active in international, national, and state organizations involved with lawyer regulation. As a member of the International Bar Association International Trade in Legal Services Working Group, another mouthful, she has represented the IBA before the WTO and the United Nations. Professor Terry has served as a special advisor to the ABA Task Force on International Trade and Legal Services, and she has served as a consultant to the Conference of Chief Justices International Agreements Committee. She has also served on the International Legal Education Committee of the ABA section of the Legal Education and Admissions to the Bar and the Pennsylvania Bar Association's Legal Ethics Committee. Before her academic career, Professor Terry was a law clerk for the Honorable Alfred T. Goodwin, Justice Alfred T. Goodwin of the U.S. Court of Appeals for the Ninth Circuit, and she practiced in the litigation department of a large firm in Portland, Oregon. Please join me in welcoming Professor Laurel Terry.
Well, thank you very much. I want to begin by thanking the University of Saskatchewan for its hospitality. It's really been a wonderful 2 days here, and I very much enjoyed it. I also want to thank Bob and Peggy McKercher for a wonderful day yesterday, touring around and learning a lot about the city and the province. And finally, I wanted to tell you how honored I was to be asked to deliver the 5th Gertler Family Lectureship in Law honoring the Robert McKercher family. I'm very, very pleased to be here. I've been in Saskatchewan before, but it was my first trip to Saskatoon, so it's a pleasure to be here. I'm going to be talking today about global trends in lawyer regulation and examining whether or not there are Canadian counterparts. As you heard, one of the most recent articles that I wrote last year was on global trends. So when I was invited to deliver this lecture, I thought it would be interesting to look to Canada and see whether I saw counterparts of the trends that I had just recently written about. So I'm going to be first setting the stage by talking about who should care about this issue? Why does it matter? And in doing so, I'll talk about globalization of the legal profession. And then I'll turn to the 6 trends that I identified, the who, what, when, where, why, and how trends, because they're easy to remember. And then to talk about why I think these trends, whether these trends matter for a province like Saskatchewan. So why should you care? I firmly believe that globalization has affected lawyer regulation throughout the world. And it's affected it, first of all, because it's changed the manner in which regulators operate. It's now much more common for regulators, no matter where they are, to do benchmarking of their policies as compared to policies in other jurisdictions. It's also become much more common for regulators to meet each other, at least once or twice in person at various conferences. I regularly attend the ABA's annual ethics conference, and there are regularly Canadian regulators there. I've been invited to speak to the Federation of Law Societies of Canada and have an opportunity to meet even more. And once you have these face-to-face meetings, then email and all of our technological advances means that we stay in contact. Also, the internet has completely changed the world. I mean, when I first became a legal academic, you could not go online and find the rules and laws of virtually every country in the world. And you can now, and that's completely changed things. So how regulators operate, their manner, is influenced dramatically by globalization. Also, the content of the lawyer regulation has changed. As you'll hear through the slides, and as you may have noticed by listening to my very nice introduction, there's a lot of international entities that have an impact on lawyer regulation, either directly or indirectly. Entities like the WTO, entities like the UN, entities like the Financial Action Task Force, the FATF, which is an intergovernmental organization you may never have heard of, but has had a very dramatic impact. So that's one reason. The other reason is that outbound policies now, domestic policies, are much more likely to influence lawyers outside of the domestic jurisdiction's boundaries, and that in turn has changed the dialogue. So for example, in the US, you may know that after the Enron scandals, we had the Sarbanes-Oxley law. And some of the early drafts of Sarbanes-Oxley were quite broad in their reach in terms of what lawyers were caught up. And so you can have policies that a country may think are domestic that have broader impact. You also have policies from other countries that may influence you. For example, the European Court of Justice decided a couple of years ago a case called Akzo Nobel, which basically held that the solicitor-client privilege, attorney-client privilege, did not extend to lawyers who worked as in-house counsel, even though in their particular EU country they might have that privilege. And so what that means is, if you're a Canadian corporation and you've got offices in the EU and you're sending documents back and forth, they might be seized, notwithstanding the solicitor-client privilege. So you have to worry about policies from other countries coming in to your jurisdiction. So all of this is to say that I think it's very important for all of us who care about lawyer regulation to know what these global trends are, because recognizing these patterns will help us, first of all, spot the issues and understand them better, and it also allows us to share our experiences with other jurisdictions, learn from their successes, but also from their mistakes. So just to give you a quick set of pictures to illustrate the degree to which this globalization has hit the legal profession, I'm going to show some slides. I realize that the people on this side of the room are going to have trouble seeing them. It certainly won't bother me at all if you want to move over a bit so that you have a better view. So this is a chart that the World Trade Organization prepared as part of a 2010 report. When the WTO was created, there were a lot of agreements annexed to it, and one of them was the GATS with an S, which covers trade and services, and that was really the first time we had a global agreement. This report is the second of two reports focusing on the legal services sector. It's focused on the two largest countries that engage in international trade and legal services, the US and the UK. And as you can see, there's been dramatic growth over time. The US, for example, has gone from $2.4 to $7.2 trillion between 1998 and a decade later in 2008. And its imports have also grown dramatically from $655 billion to $1.75 trillion. And the UK picture is similar. The Canadian picture is also similar. This chart was generated from data from the Foreign Affairs and International Trade Office, and Canada went, for example, from $275 million to $719 million for its exports. It went from $226 million to $709 million. And what this shows you is that legal services are big business. And it's also noteworthy, I think, that Canada's exports of legal services are larger than its imports. And given the relationship between the US and Canada and being some of each other's largest trading partners, I think it shouldn't come as a surprise that when the WTO report talked about which parts of the world had the largest percentage of international trade and legal services, it was the Americas, pretty dramatically. And in the US, Canada is our third largest. This is from a 2011 report. They use data that's a little bit old. Canada was our third largest trading partner for exports and our fourth largest trading partner for legal services imports. From the Canadian perspective, the U.S. was by far your dominant trading partner for both imports and exports, and that's been true over time. Now, it's easy to think that this issue of globalization and the legal profession is just a big city, big law phenomenon. Okay, that's relevant if you're in Toronto or New York or London, but it's not me in Saskatoon. And I disagree with that perspective. I've written an article called The Legal World is Flat that is basically a riff on Thomas Friedman's book, The World is Flat, if you know that. So I went through all the factors he analyzed and said, okay, here's what he said. It seems to make sense. Does that apply in the legal world? And my conclusion was yes. I mean, he talks about how technology has changed the ways in which we all operate. And I think that's clearly very true in the legal world as well as elsewhere. And one of the things that that's meant, I think, is that when we talk about globalization in the legal profession, it's not just the multinational corporations and the global law firms who are engaged in this. Businesses, anybody that's got a business of whatever size, there's a good chance that they have interactions around the world. And so at some point, you're going to have lawyers from around the world who need to negotiate a supply relationship or a sales relationship. And so therefore, some of the statistics that I thought were very important in the U.S., I went to investigate the Canadian counterpart, and I found that they were also true. Statistics Canada did a study in 2010 of the projected diversity of the country by the year 2031. And what they said is that between 25 and 28% of the population could be foreign-born. This was an amazing statistic to me, that by the same date you could have 46% of Canadians older than 15 years who will either be foreign-born themselves or they'll be second generation. They'll have at least one parent. And consider what this means for small businesses and for individual clients. It's much, much more likely now that they are going to start a business where they're either selling or buying from places elsewhere in the world, where they have inheritance matters or family law issues. And the more diverse your population is, the more likely they have those connections or are going to be able to start those businesses. Now, if you haven't yet heard the acronym BRICS, I'm mentioning it now, and I assure you if you start looking, you will see it everywhere. Shows up in the newspaper, shows up in radio stories. BRICS is the acronym for Brazil, Russia, India, and China, and South Africa actually fairly recently joined in with the group, so it's now BRICS, not BRIC. And the term has been credited as originating with a Goldman Sachs report that talked about the global shift in the economy from the traditional powerhouse old economy countries to the BRICS countries. And if you look at this chart, you can see the dramatic growth of the BRICS countries by 2050, with them overtaking the G6. And this is another chart from the Stats Canada study. And as you'll see, the foreign-born population of Canada is projected to change dramatically by 2031. So instead of having your foreign-born population from Asia constitute 14% of the population, as they did in 1981, they're projected to constitute 55%. And so the Asia group here includes both China and India, which are part of the BRICS groups. And so what that means is that Canada, I think, is really well situated to have a lot of individuals with contacts who are in a position to take advantage of this shift in the global economy. And so for this reason, I concluded that the same factors that I saw as being significant in the U.S. would probably be significant in Canada as well. And this is a chart, again, from the same study that shows you which percentage of the population belonging to a visible minority group. So again, that includes China, Indian population, is in which age group. And notice that there's a lot of increase in the age group of people in their prime earning years when they're going to be establishing businesses and making contacts. It's going to go from 20% to basically 36% in the younger group, and then 12 to 30%. So again, it seems to me that this is part of your future and part of why the phenomenon that the World Trade Organization has documented about globalization in the legal profession applies here as well as elsewhere in the world. So with that background, I'll turn now to the trends that I had identified, the who, what, when, where, why, and how. And for each of these trends, I'm first going to be showing you a slide dealing with the global trends, and then I'll show you a slide that deals with some of the Canadian counterparts that I came up with. And I am covering an incredibly vast amount of territory in this talk, and so the way that I'm doing it is I'm just showing you snapshots of the logos or screenshots from some of the leading events. And I won't have time to go into detail about all of this, but there's going to be a Q&A session afterwards, and I'm happy to answer in that session or thereafter by email any questions you might have. So one of the key issues that seems to be being raised around the world is this issue of who should regulate lawyers. People are asking that question a lot more than they ever used to, and sometimes they are answering it by changing, in some cases quite dramatically, who it is who regulates lawyers. And in 2007, the Legal Services, the UK adopted a Legal Services Act that dramatically reshaped regulation of the legal profession in England and Wales. And they created an overarching legal services board. Should ask for a pointer. That's right in the middle here. And that board, by statute, is required to have a non-lawyer majority and a non-lawyer chair. And that board then authorizes what are called the frontline regulators. It's the Solicitors Regulation Authority, SRA, for solicitors, and the BSB, Bar Standards Board, for barristers. The similar kinds of movements are happening in a number of countries. Scotland has completely changed its regulation. Ireland has pending right now legislation to completely redo their Legal Services Act, and the first draft took lawyers out of the mix entirely. Remember, in the UK, they just said non-lawyer majority and no lawyer chair, but Ireland, they wanted them out. In Law Council in Australia, they've gone through some quite dramatic changes in their lawyer regulatory structure, which has led to some events I'll talk about later. One of the more interesting developments is something that's now being referred to as the Troika, which is some European countries, as you know, have run into severe financial trouble and have needed to be bailed out. And so the International Monetary Fund, the European Central Bank, and the European Commission have been getting together. They're referred to colloquially as the Troika, and have been imposing conditions on the bailout that require changes in the lawyer regulation system. And some of these have been very controversial. The ABA, American Bar Association, and the EU's Bar Association, called the CCBE, sent a joint letter to the managing director of the IMF saying, we think you're really compromising lawyer independence here. She wrote back and said, no, we think it's fine, don't worry about it. And then they're negotiating. But again, it's a lot of questions being asked now about who should regulate lawyers, and sometimes dramatic changes that accompany this. So what about in Canada? I think that you have some of the same dialogue going on here. You may know that there is longstanding litigation between the Attorney General of Canada and the law societies with respect to the proceeds of crime legislation and lawyer confidentiality. So again, it's this question of who should be regulating lawyers on that issue. Is what the law societies are doing sufficient, or do you need the government stepping in? The Canadian Competition Bureau in 2007 issued a report for all self-regulated professions, including the legal profession, and raised a number of issues where they really thought that they had concerns about antitrust issues in connection with various issues of lawyer regulation. A number of provincial legislatures, not here in Saskatchewan but elsewhere, have decided to include the legal profession within broader consumer protection statutes that they have, stating basically good regulatory practices for admission, for example. And so that's a change in who regulates lawyers. The Federation of Law Societies of Canada is an umbrella organization of the law societies. It has no direct power, but it's certainly become much more active in terms of trying to develop a consensus on a national consensus on various issues, including admissions, legal education, ethics rules. They have the new code, which is being implemented, discipline. So now when you ask who regulates in Canada, I think you've got to mention the FLSC as a significant player, even though it may not have direct power. You have a lot of Canadian academic commentators who are asking these questions about who should regulate lawyers. That's actually a parrot up there. I couldn't quite find a dead parrot to represent Harry Arthur's famous statement about self-regulation in Canada being a dead parrot, but that's the closest I could get. And then you have these international entities, all of which potentially have a very large impact on Canadian lawyer regulation. The WTO is currently negotiating what it calls disciplines, which, in my view, in essence, would be a WTO level of regulation. And if you don't comply with any disciplines that ultimately get adopted, the remedy is trade sanctions, but that can be a very powerful tool. And so the Federation and the Canadian Bar Association, for example, have both sent commentaries in to the government about disciplines. The Organization for Economic Cooperation and Development has been very active here in this issue of who should regulate, and I'll mention them again later. So the second issue that I identified was the issue of the object of regulation. Even if you know who should be doing the regulation, what or whom should they be regulating? Traditionally, we just regulate people, providers, and traditionally it's been lawyers. But maybe regulators should be trying to regulate services. And now there's questions being raised about, okay, do you regulate people or can you also regulate firms? And there's been a tremendous amount of activity globally going on with respect to this question of who or what are regulated. Slater and Gordon, I have their logo here. This was the first publicly traded law firm in the world. It's in Australia. You can go buy shares of this law firm on the Australian Stock Exchange, and it's very interesting to read their prospectus. The UK, as of March of 2012, so less than a year ago, began issuing licenses for what are called alternative business structures, or ABS. ABS theoretically could allow publicly traded law firms. So far, what they've just had is outside investment. It hasn't actually gone to the stock exchange. But the co-op, which is very influential in the UK, as you can see, they sell food, banking, insurance, electrical, pharmacy, travel, funeral care, and legal services. They got an ABS license. They said that they are going to have 3,000 solicitors in the UK within 5 years. And it's really going to change, I think, what's called the high street market there. There have been private equity hedge funds that have been issued ABS licenses. There have been transatlantic law firms that have applied for them. There have been previously insurance claims management companies that have received licenses. It's really quite a dramatic change. And regulators have to decide, okay, do we regulate these entities or don't we? It's a whole new ballgame. You also have now these online providers. LegalZoom is the provider in North America. Legal 365 is the provider in the UK. And at least in the US, they say they're not providing legal services because they'd run into our unauthorized practice of law. But if you look at it, it looks pretty darn close to what somebody might go to a lawyer for. So what about the situation in Canada? I think that you've got the same dynamic going on here. One of the things I did preparing for this talk and for the law review article that will be published as part of the symposium on the future of law was to look at the annual reports and some of the benchers bulletins for the law societies throughout Canada. And one of the things that I discovered is a number of law societies are explicitly asking the question, do we regulate services or do we regulate providers? There are a number of academics in Canada who are asking this question. And I wanted to give a hat tip to Jordan Furlong, who's a futurist and commentator in Canada, because he's the first one that I ever heard speak about this, who really crystallized this issue so succinctly for me. He spoke at a 2010 meeting in the Federation Law Society of Canada, and he got up there and told regulators, you have to decide this question. The world is changing. You have to figure out what business do you want to be in. Now, the Law Society of Upper Canada has decided that it now regulates paralegals. So if you go to their website, you'll see they have a page for the public, for lawyers, and for paralegals. And a number of other law societies are also considering this idea. For entity-based regulation, do we regulate firms as well as people? They do in Nova Scotia. They do in British Columbia. Adam Dodek has written an article asking whether that should become the norm. And other law societies have floated the issue and said this is something that we should be talking about. So again, with respect to the second trend, I definitely found a counterpart in Canada. And this may look familiar. This is from the Saskatchewan Benchers Digest from less than a year ago. And there was a pointing out that the Law Society Gazette advises us that SRA, the regulator, can now issue licenses to the alternative business structures, and they have in fact done so to the co-op. Could this be the future in Saskatchewan? So it's not that this issue is going to stay bounded by the ocean. There's going to be discussion, there's going to be debate. So the next trend that we identified in our 2012 article was the trend of when lawyers are regulated. Should you try and regulate them before problems occur or after problems occur? And as I mentioned, Australia also has had dramatic changes to its Legal Profession Act. And these changes, which allowed incorporated legal practices and ultimately publicly traded firms, were not done at the behest of the legal profession. It was really done at the behest of the legislature. But the statute that established incorporated legal practices had 3 words in it. It said, if you're an ILP, you need to have appropriate management systems. And the regulator in the Australian state of New South Wales basically decided to run with those 3 words. And so he and his office called together a lot of stakeholders, and the first thing they tried to do was come up with a top 10 list of problems between lawyers and clients. And I suspect their top 10 list would have at least 9 of the same problems that you would come up with in any jurisdiction. Not returning phone calls, missing deadlines, not having fee agreements, things like that. And then what they did is they created a self-assessment document. So if you want to be an ILP, which is voluntary but has tax benefits, you have to go through the self-assessment process where you say whether or not, with respect to these 10 problem areas, you are fully compliant, partially compliant, or not, in which case you go fix it. And then they gave people ideas. They didn't specify exactly what it took to be compliant, but they gave them ideas. For example, on fees, have a written fee agreement. And they gave them a lot of online resources. It's basically law practice management. What happened? They had an academic who was given access to their data. Client complaints went down by 1/3. Really dramatic. So what about in Canada? Well, first of all, I have to tell you that the New South Wales regulators, Steve Mark and Talia Gordon, have really been on road trips around the world. Everybody wants to hear about it. And so I would say that there's a good chance that lawyer regulators around the world know about this, and the Canadian regulators definitely know about it. They've met, sometimes in person, with Steve and Talia and have heard about these results. Now, one of the things that I was very excited by is, as you heard, I had written an article saying that there should be a global umbrella organization to bring lawyer regulators together, because there really isn't anything for day job regulators. And this past September in London, the UK SRA organized a conference. And one of the people who was there was the Zina Olsen from the Law Society of Upper Canada. She was on a panel dealing with this topic of when you regulate. And she's quoted on the webpage, or summarized on the webpage, as having said that, Canada is somewhere in between proactive and reactive, but probably falls a little bit more on the reactive side. But there hasn't really been a gathering storm for change. Well, there may not be a gathering storm, but I have to tell you, I see sprinkles. Because if you look at what the Canadian academics are saying about when to regulate, people have noticed the empirical results in Australia and the big drop. And so, for example, Alice Woolley, who's a leading Canadian legal ethics academic, in an article last year, said that law societies should emphasize standard setting and other proactive oversight activities rather than responding. So you have a dialogue going on already, and I think you should expect to see this conversation continuing. So the next issue we identified was the issue of where lawyers are regulated. I think with very few exceptions, there are a few systems where you're regulated by discipline according to particular court that you may be a member of, but generally speaking, lawyers around the world are regulated by geography. You're admitted to a particular geographical entity. They regulated you when you were in that entity, and when people didn't travel much, it didn't matter. But we've now morphed into a virtual world where lawyers can be answering client calls from a beach in Tahiti and the client never knows it, where you can access the internet from everywhere. And in fact, you now have virtual law firms that just don't even have a bricks and mortar office. Stephanie Kimbrough has gotten a lot of publicity in the US as part of the ABA Ethics 2020 Commission, and she's also active with the e-lawyering blog, because she's a very young lawyer with kids at home who wanted a flexible schedule and has developed this structure of a virtual law office with a series of questions clients go through and answer before you finally get to the point where you're talking with a lawyer. And she says clients love it. They don't have to drive and find a parking spot. They don't have to set up an appointment. They can do it in their slippers and their jammies on their schedule. So it's an issue that really regulators around the world are having to grapple with, and there are no clear answers. I once sat at a dinner with a nice argument going on between a U.S. state regulator and a lawyer in a relatively large law firm about whether the World Trade Organization GATS agreement applied to lawyers who had websites located in other states that reach clients in that state. We just don't have models for this. Do they or don't they, are they or aren't they subject to the regulation of the regulator? So what about Canada? So I think you've got the same issue here. And you'll see, if you look up Tom, I'm quoting you here. It's an exciting time to be a lawyer, but watch out. Over the next 10 years, we may see more changes in the delivery of legal services than we've seen in the last 100 years. I think that's absolutely true. And so, for example, you have virtual law firms in Canada, and you have regulators trying to figure out how to respond to it, and you already have online fights between regulators and virtual law firm members saying, I don't think the regulators got it right here. You have people trying to figure out how to deal with cloud computing. Clio, whose sign is there, is one of the big cloud computing providers for lawyers in Canada. And they're not targeting big global law firms. They're targeting, there's a big essay in Family Lawyer magazine. So the sort of lawyers that you could have anywhere in small towns, not just in global centers. Adam Dodek, who's another leading Canadian legal ethics commentator, has said in writing about ethics for the 21st century that one of the macro challenges is going to be figuring out the ethical jurisdiction for lawyers who leave the border. So trying to figure out how to make this system work. Legal-wise, I have their logo there. They are an outsourcing company. And elsewhere in the world, there have been lots of issues raised about how far the obligations go of lawyers who use outsourcing, and to what degree you are guaranteeing the work product, to what degree you're responsible for it. So I have every reason to think that in Canada, these issues that are all blended with the issue of where lawyers regulate are just going to continue to grow. You also have the creative law uses something called the direct law platform, which has also been discussed quite a bit in the ABA Ethics 2020 initiative. So another one of the trends that we identified was how lawyers are regulated. And again, as part of the dramatic changes in the UK, the SRA, which is the frontline regulator for solicitors, has gone to what's called outcomes-focused regulation. Now, sometimes people are not 100% sure what this is going to mean in operation, but it is a much more principles-based as opposed to rules-based system of regulation. And so there's been a lot of discussion about that. There's been discussion in the UK and elsewhere in the EU about whether or not we should get rid of unitary regulation of lawyers. Right now, most countries regulate all lawyers the same. Doesn't matter if you represent a global multinational client or if you represent, a one-time, unsophisticated individual client, we regulate the same. But there's been a lot of discussion that maybe we should have differential regulation. There's been discussion about whether or not to have entity-based regulation, whether the entity is the law firm or this bigger entity of ABS, like you now have in the UK. So what's the picture in Canada? I think you should expect to see these same types of discussions about how lawyers are regulated. First of all, one of the things that I found interesting when I was doing my research is that apparently in a number of other fields in Canada, outcomes-based regulation is the way they operate. And that's true in the securities field, and it's even true post-crash. So you have precedent for having this system. There have also been calls about whether or not unitary regulation of lawyers really makes sense. Alan Hutchinson, another leading Canadian academic, legal ethics academic, wrote an article focusing on government lawyers and talking about how what they do is different than what some other lawyers do, and posing the question of whether and when it should ever come to a time where you have differentiated regulation depending on who your client base is. And a lot of people have noticed what's going on elsewhere in the world within Canada. So you're having these discussions. I will point out that the Canadian Competition Bureau's 2007 study of self-regulated professions, one of the very first chapters was on regulatory principles and how to regulate, taken from the work of the OECD. And that was one of the first times I ever ran across that and realized the impact of these organizations and talking about regulatory theory. The Fair Registration Practice Acts, which you have in the equivalent of in 3 Canadian provinces, are really about how to regulate. And they didn't trust the law societies to do it right, so they told you how to regulate in those provinces. So I think you're going to see continued discussion of that. The last item that we talked about was the issue of why lawyers are regulated. And as you heard in the introduction, that was one of the 2 articles that I co-wrote with Steve Marcantalia-Gordon last year. And I was very taken with Section 1 of the UK Legal Services Act. In my mind, it's the best part about it. Because they asked the question, what are we trying to accomplish with lawyer regulation? And they came up with 8 different items. After debate, they decided not to prioritize them. These are sometimes going to come in conflict, but at least you've set the parameters for what are appropriate goals and presumably inappropriate goals. And they had some real debates about what made it into this list. They had very late amendments where things have been left out. But I think that having something explicit like this that frames the dialogue is incredibly useful. We don't have anything like this in the US, so that was part of why I wanted to write this article. Well, what about in Canada? The Canadian provinces have regulatory objectives. They're not uniform from province to province, and my sense is that they haven't gone through, at the outset, the same sort of rigorous debate that you had in the UK, because they've been in the Legal Profession Acts, in many cases, for a number of years. So they haven't had the real knockdown, drag-out fights that you had in the UK over this. But they have had them, and what you're now starting to see are discussions in Canada about whether they have them absolutely perfect or whether they should be tweaked. And so you're starting to see changes and discussion about the regulatory objectives, which I think is a wonderful thing to be happening, and I hope that I can prompt that to happen in the US as well. So, does any of this matter in Saskatchewan? I pulled the Federation of Law Societies of Canada 2010 statistical report. And according to that report, you have 1,929 practicing members. As of the time of that report, there were 3 firms with more than 51 lawyers, 1 firm with 26 to 50 lawyers. There were 0 foreign legal consultants in Saskatchewan. So I think it would be easy to say, we're not Toronto, we're not New York, we're not London, it doesn't matter. And it would also be easy to say, and there's a lot bigger issues to worry about. For example, if you go to that same statistical report, you'll see that 40% of Saskatchewan lawyers have been in practice for 26 or more years. And that raises a number of issues, one of which is just aging lawyers and transition. You also have potential issues about shortage of lawyers in rural areas and who's going to take over when this cadre of lawyers is no longer practicing. And I don't mean my talk to say those are not incredibly important, incredibly pressing issues. But I do think that the themes that I've been talking about tonight are also important and are things that we need to be aware of and we need to talk about, because it's, as I said at the outset, I think all of these developments, everybody's interconnected now, right? If you have a financial crisis in one part of the world, it affects another part. If you have an environmental disaster in one part, it affects the other. And that is now true with lawyer regulation. Developments that happen in one part of the world, people talk to each other. They say, well, if it's good enough for them, why isn't it good enough for us? There's conversation going on. And I pulled this from a news item on the Law Society of Saskatchewan's webpage, not to mention that you're seeing an unprecedented increase in the demand for land coming from investors across Canada and beyond. So even without this outside investment coming in, I think you should still be worried about this. But clearly you have this globalization and influx. And clearly there's a lot of trade in Saskatchewan, in Canada, and what that means is that the lawyers are following the clients, and they're going everywhere. And so I think being aware of these global trends and being able to spot when there are counterparts that might be happening in Canada, I think will make us all more reflective in our dialogue, and I think will give us insights about what works and potentially what doesn't work. And so in short, I think that the more global communication we have, the better off we all are, and the more global knowledge. And on that note, I want to thank you for inviting me to come from the U.S. To share my perspectives with you, because it's been a wonderful learning experience for me. I sat in on a legal ethics class today, which was great, and hopefully it's been equally useful for you to engage in this dialogue about global trends. So thank you very much, and I'm happy to answer questions.